Okay, good afternoon, everyone. My name is Sabina Magliocco. I'm the chair of the program in religion and a professor in the Department of Anthropology here at UBC. And I'd like to welcome you to the Roundtable on Religion, Law, and Society, sponsored by UBC's program in the study of religion and the Public Humanities Hub. I'd like to begin by acknowledging that the UBC campus, as well as the land that I am living on today, is located on the traditional, ancestral, unceded territory of the Musqueam people. The land it is situated on has always been a place of learning for the Musqueam people, who for millennia have passed on their culture, history, and traditions from one generation to another on this site. I'd like to thank the Public Humanities Hub, especially the director, Mary Chapman, and our capable program assistant, Heather Tam, for their support, which made this program possible. Thanks also go to the Faculty of Arts and the first year interdisciplinary programs for their assistance. And I'd like to extend a special thanks and welcome to all our panelists this afternoon who took time from their busy schedules to share their expertise with us. Even at a time when the percentage of people in Canada who identify as unaffiliated with any religion is growing at an unprecedented rate, religion remains an important part of identity and practice for billions of people, both in Canada and throughout the globe. Religion intersects with legal systems in a number of interesting ways. Religion and the law are frequently complementary. The earliest human laws grew out of religious systems that sought to regulate human behavior as societies grew increasingly complex. Liberal democracies seek to decouple religion from the law in order not to favor any single religious group. Yet their laws are inevitably still colored by the precepts of the dominant religion, which can exclude or fail to recognize principles fundamental to indigenous and minority religions. In multicultural societies today, the laws of some religious minorities come into contrast and conflict with federal and provincial laws. The presentations at today's roundtable will explore these issues through a series of case studies. Now, there are hundreds of thousands of religions and religious denominations in the world, so we cannot do them all justice. The purpose of these presentations is therefore not to be comprehensive or representative of all religious traditions, because that would be impossible, but to present some ways of thinking about the intersections between religion and the law, and to explore their implications and effects on the broader society. Our panelists today come from a variety of backgrounds. Dr. Carol Blackburn is an associate professor in the Department of Anthropology at UBC. Her research focuses on law and rights as tools that Indigenous people use to mediate their relationships with states. Dr. Blackburn has written on the legal, political, and cultural consequences of treaty making in Canada and the challenges of litigating loss of culture in residential school litigation. Dr. Robert A. Daum is a fellow at SFU's WASC Center for Dialogue. He researches rabbinical legal literature and history, Talmudic poetry, gender and queer studies, authority construction, hate crime, comparative religion, and human rights. He collaborates with universities and governments to advance EDI plus and reconciliation. Dr. Yulen Etchabe is Assistant Professor and Canada Research Chair in Jurisprudence and Human Rights at the Allard School of Law. He is the author of The Experience of Tragic Judgment and the editor of 3 other books, including Cultural History of Law in Antiquity, Rancière and Law. His current project seeks to unearth a dialogic form of judgment emerging in the context of international human rights. Dr. Hoi Kong is the inaugural holder of the Right Honorable Beverly McLaughlin, PC, UBC Professorship in Constitutional Law, which he assumed in 2018. He researches and teaches in the areas of constitutional, administrative, municipal, and comparative law, and constitutional and public law theory. He has also taught at McGill's University Faculty of Law, where he served a term as Associate Dean Academic at Queen's University and at the Columbia Law School. Professor Kong clerked for Justice L'Heureux Dubé and Justice Deschamps at the Supreme Court of Canada. We are privileged to have with us today as a discussant the Honorable Justice Jeffrey B. Gomery of the Supreme Court of British Columbia. The Honorable Justice Gomery received his LLB from the University of Toronto in 1983 and a Bachelor in Civil Law from Oxford University in 2005. He practiced as a partner with Nathanson, Schachter, and Thompson LLP and became Queen's Counsel in 2010. He became a Fellow of the Chartered Institute of Arbitrators in 2018. Since 2012, he has served as an adjunct professor at the University of British Columbia in the Peter Allard School of Law, teaching a course he created on the law of restitution. In 2018, he was appointed Justice of the Supreme Court of British Columbia. Our panelists will present in alphabetical order. There will be time for audience questions and discussions. I will ask that you hold your questions until all presenters have had a chance to present and Justice Gomery has commented. You can ask questions by typing them in the Q&A feature, and I will then read them out. Our panelists will answer. So without further ado, let me turn the roundtable over to our first presenter, Dr. Carol Blackburn, who will be speaking on defending grizzly bear spirit in Canadian courts, Tunaksa First Nation versus British Columbia. Carol.
Thank you, Sabina, for that introduction, and welcome everybody. I'm very pleased and honored to be invited to participate in this roundtable. I do have some slides, so I think if I get those up and then I will give my short presentation. So hopefully this works. Okay, thank you. Right, so again, thank you so much for the invitation. The case that I thought would be a really interesting thing to present to this roundtable today concerns a proposed ski resort development in Jumbo Valley. Jumbo Valley in the southeastern corner of British Columbia, and the attempt by the Tunaksa First Nation to prevent the construction of this ski resort on the basis that Jumbo Valley is for them an area of primary sacred and spiritual importance as the home of grizzly bear spirit. And you can just see there are many images of Jumbo Valley available. It is a spectacular place. And if you can just see the one image on the side of on the right side of the PowerPoint slide, it's a spectacular place. It is located in the Purcell mountain range. For those of you who may know the interior, southeastern interior of our province. But it's located in the Purcell mountain range near the town of Invermere. And it was identified as the potential site of a new ski resort by a well-known Vancouver architect and developer and ski enthusiast by the name of Oberto Oberti in the early 1990s. After 20 years of environmental reviews and consultation, including with the Tunaksa and other First Nations and regulatory staff, the provincial minister responsible for forest lands and natural resources did approve a master development plan for the resort in 2020. And I have a sort of an image here. The resort master development plan included multiple lifts to the glaciers that surround the peaks, that are on the peaks, and a permanent resort site in the base of the valley. The resort was to include lifts to glacier runs, overnight accommodation capacity at over 6,000 beds for guests and staff. And the proponents of the resort argued that it was going to be a world-class international sort of Olympic quality resort that would attract not only four-season skiers, but wilderness tourism and sightseers, etc. The Tunaksa opposed it, as I will explain, but environmentalists opposed it, wilderness aficionados opposed it, inhabitants of the nearby towns and region also opposed the development of this resort, on multiple bases, on the basis that it was going to destroy important grizzly bear habitat, on the basis that it would ruin the wilderness qualities of the area, and on the basis that another ski resort was not needed in this part of the province. A neighboring First Nation to the Tunaka supported the resort, and the Tunaka are not the only First Nation who do assert claims in Jumbo Valley. So the Tunaka brought their claim against the development of this resort. They brought it through the Supreme Court of BC, the BC Court of Appeal, and then to the Supreme Court of Canada. And they brought their case on two grounds. The first ground was that the construction of the resort would violate their freedom of religion under the Charter, under Section 2A of the Canadian Charter. Section 2A, which states that all Canadians are guaranteed certain fundamental freedoms, the first of these being the freedom of conscience and religion. They also brought the case on the basis, they also brought the case using the argument that the minister failed to adequately consult. The minister failed to adequately consult them in respect of a Section 35 right, Section 35 Aboriginal right to practice their religion. Section 35 Aboriginal rights and charter rights are separate things, and I'm not going to discuss the Section 35 component of the case in the time that I have today. As this unfolded, the Tunaka spent a lot of time presenting their argument about why Jumbo Valley was sacred in documents, in court testimony, etc. In 2010, they issued this. They issued the Katmuk Declaration. And I just have a portion of it here to show you. In this declaration, they spelled it out. They asserted that Katmuk is a very special place to them. It is the place where grizzly bear spirit was born, goes to heal itself, and returns to the spirit world. They explain that grizzly bear spirit is an important source of guidance, strength, protection, and spirituality for their community. And they explain that they have a stewardship obligation and duty to protect grizzly bear spirit and Katmuk. The stewardship obligation and duty blending a spiritual obligation and a legal obligation. They called for the establishment of a refuge area in the valley and a management plan. They explained that they did not object to temporary uses of the valley for wilderness backpacking, some skiing, etc., some backcountry skiing, but that their concern was with the construction of basically a permanent town at the center of the valley that was looking to attract 3,000 visitors per day. They also explained that they did not always have to go to the valley itself to conduct their ceremonies in respect of grizzly bear spirit, and that did turn out to be a factor in the ruling. So those of you who have legal expertise will know this perhaps better than I do, but for an infringement of Section 32, for an infringement of Section 2A to be found, two things have to be in place. The claimants have to demonstrate that they sincerely believe in a practice or sincerely have a belief that has a nexus with religion. Religion is critical. The other thing that the claimants have to prove is that the measure, in this case, it would be the building of the ski resort, or the state conduct at issue interferes in a way that is not trivial with their ability to act in accordance with their religious belief or practice. Those are the two things that a claimant has to establish for an infringement of the Charter, Section 2A, to be found. In the case at hand here, the majority of the Supreme Court of Canada found that the first part of this charter test was met. They found that Tunaka did, I think I'll just move that. I'm going to move this back. They found that the Tunaka did have a sincere belief in grizzly bear spirit, and that this belief was a critical component of their religion. The Supreme Court of Canada did not find that the second part of the test had been met. They did not find that the construction of the resort was going to impinge in a more than substantial way on the ability of the Tanaka to act in accordance with their belief in grizzly bear spirit. The Supreme Court wrote, among other things, that the duty of the state under Section 2A of the Charter is not to protect the object of belief, like grizzly bear spirit, but rather the duty of the state is to protect everyone's freedom to hold beliefs and to manifest them in worship or practice or teaching or dissemination. The court argued that what was going on here in this case was that the Tanaka were not seeking protection for the freedom to believe in grizzly bear spirit or to pursue practices related to grizzly bear spirit, but the court argued the Tanaka were seeking to protect grizzly bear spirit itself. And the court argued that this claim is beyond the meaning or the scope of Section 2A of the Canadian Charter. There was a dissenting minority opinion. I'll just point that out. Justices Moldaver and Cote argued that the second part of the infringement test was met and that the building of the ski resort, the construction of the ski resort would substantially infringe on the Tanaka Nation's ability to practice their religion. So this case is interesting for a variety of reasons. It was the first time that the Supreme Court of Canada interpreted Section 2A of the Charter in relation to an Indigenous right to freedom of religion. Previous jurisprudence of the court states that the Charter is supposed to be interpreted in a broad manner. It seems, though, I would suggest that in its interpretation of what Section 2A protects, the majority of the court relied on an idea of religion as a matter of individualized practice and belief, separate from places or landscapes. I suggest that the interpretation of the court does disservice to Indigenous belief systems and will lead to more failures to legally protect Indigenous sacred sites, begging the question of what good this section of the Charter is if it can't protect Indigenous claims to religious freedom. This ruling does not consider the unique nature of Indigenous land-based relational ontologies, and in so doing essentially excludes Indigenous spirituality or religious claims from Charter protection. I would also suggest that the court is operating with a secular approach to protecting the rights of individuals to believe. But the underlying and unstated ontological assumption of the court is that different beliefs exist within a uniform natural world. Possibly another way of saying that is the law at operation here rests on a liberal political philosophy that emphasizes individual rights, certainly not the rights of spirit, and a modernist post-Enlightenment scientific worldview whereby the natural world is knowable and uniform in its operations. Finding space to tolerate diverse beliefs and practices within a secular state is not perhaps the same as actually engaging the possibility and providing protection for a distinctly different ontology. I would also like to point out that another crux, another important issue in this case was the way the right of religious freedom claim blurred into a property rights claim. And I know there isn't much time left, but this was important in this case and is important in Indigenous sacred space claims in Canada. The Tanaka assert Aboriginal title over the area of Katmuk as their traditional unceded ancestral territory. They didn't assert it in this case specifically, but generally they assert Aboriginal title over the area. The province of BC and the courts, however, understand Jumbo Valley and the surrounding area to be crown land, to be public land, and understand the Aboriginal title of the Tanaka to the area to be asserted but not proven. So a component of the court's ruling was that any right of religious freedom cannot interfere with the behavior of third parties who are non-adherents to the religion, and in particular cannot interfere with the property rights of third parties, cannot interfere with third parties' lawful uses of property. Given the colonial history and keeping in mind that the court is understanding Jumbo Valley to be Crown land under the jurisdiction of the province. Given the colonial history of British Columbia, certainly many Indigenous sacred sites are on Crown land that is subject to multiple competing interests, logging, mining, ski resort development. This is a further hindrance and detriment to the legal recognition of sacred spaces for Indigenous people in Canadian courts. Now, my time is up, but I just wanted to point out, some of you may be aware of this, but the story does have a better ending. Katmuk is now an Indigenous protected conservation area. For a variety of reasons, the glacier resorts and it's Oberti abandoned the project. Those reasons include that they found a better site further north in the town of Valemount to build a very similar resort, and their environmental certificates ran out. And in the meantime, the federal government, the province of BC, a number of nature conservancies, the clothing manufacturer Patagonia, and other interests, private and public, combined to contribute over $20 million to the establishment of this Indigenous protected conservation area within Katmuk. And the Hunaka First Nation are now engaged with their membership in developing a plan to move forward with this protected conservation area. Thank you. That concludes my talk. Stop share.
Thank you so much, Carol, for a very interesting presentation that begs so many questions about laws in liberal democracies and what they see and don't see as legitimate religious practice. Our next presenter, Dr. Robert Dahm, will speak on harmful speech, aspects of rabbinic teachings about intent, impact, and culpability. Robert.
Thank you very much. I'm delighted to have been invited, Sabina, Justice Gomri, and distinguished colleagues, and I am sure fascinating participants. Wonderful to be here with you. I am delighted to be participating from the traditional and unceded lands of the Abenaki Nation at Missisquoi, the Quausec Band of Quaus Abenaki Nation, in what is otherwise known as the state of Vermont, which in 2012, I believe, recognized the Indigenous ancestry of these lands, which is pretty good. It was only 13,000 years, but that's better late than never. I don't mean to make light of this. It's actually quite serious, and I'm really proud to have become a Canadian citizen in about 20 some years ago, not quite that many, because of our appreciation for the importance of recognizing and thinking deeply about and wrestling with the implications of what that means. I'm delighted to be able to speak to you about a really vexing area of public policy and I research and the experience, I think, of many people in their daily lives and their workplaces, and particularly the experience that disproportionately affects marginalized groups, people with intersecting identities that are subject to discriminatory treatment of one kind or another, and particularly speech. So I want to just say a little bit about hate crime and hate speech, about slander, defamation, and then link it to microaggression in a couple of ways, and then illustrate the ways in which the terms that we use, as is not uncommon, the terms that we use to try to capture or signify a particular concept haven't quite caught up. And I'll explain what I mean by that. So first of all, some of you may know that it is not easy for prosecutors to secure a conviction for someone who is charged with a hate crime. Primarily, we think about the public incitement of hatred or the law prohibiting the willful promotion of hatred. And willful promotion of hatred is particularly difficult because one has to prove intent. I'm sure many of you know that the BC Human Rights Code also prohibits discriminatory speech. What's really important to think about in terms of the dilemma of the hate crime phenomenon is, and this I'm happy to say I was able to learn much more about this subject with the support of a criminology graduate student team of researchers at SFU. What really struck me was the fact that some estimates are that up to 90% of cases of hate crime are underreported or unreported. And researchers have pointed to, by some measures, as many as 7 different points along the path from the instance itself to getting to the point of actually securing a conviction. And there are many reasons that hate crimes are underreported, researchers believe, or underreported. The arresting officer might not note that it appeared to be a hate crime. Some other crime might be cited in the records. The victims might not be able to pursue their complaint all the way along the line. They might tire or be traumatized repeatedly by having to repeat the story again and again. But what's really important to pay attention to is our researchers suggested that of all the categories of crime, victims of hate crime are more likely to be re-victimized by hate crime than any victims of any other category of crime. And we know that there are many harmful effects from hate crime, or hate incidents that don't quite make it to the point of being prosecutable or of resulting in a conviction. There's research pointing to the harms to an individual's health, harms to family and communities who share identity characteristics. There's a ripple effect to an incident of this kind. It can affect one's physical health. One can become reluctant to pursue one's career, to advance oneself, to put oneself out there. So there are many harms, and those of us who work in this area I think are rightly prioritizing the experience of the victim who has been harmed, and taking a victim-centered approach and a trauma-informed approach. But if we know that hate crime victims are more likely than not to give up pursuing their case, then we need to pay close attention to their first experience, the first place they file a complaint, the first person who sees them. And one of the many reasons that hate crime victims cite, according to the research, for not reporting a hate incident is an unsatisfactory experience the first time that they tried. So the reason I wanted to mention this is because it's connected to the topic I wanted to focus on more closely, which is microaggression. A colleague, Esteban Vallejo Toledo, pointed out to me, and I'm really grateful to him because I had not remembered this, that Ibram Kendi rightly is very critical of the term microaggression. As he puts it, Kendi puts it, a persistent daily low hum of racist abuse is not minor. What other people call racial microaggressions, for example, Kendi says, I call racist abuse. The problem with Kendi is that micro makes it sound small, and aggression is not necessarily helpful because of the subcategories. Racialized microaggression is quite different than just using a generic term like microaggression or aggression. So at any rate, the term itself is problematic. Now, microaggression researchers, theorists, people who think about this carefully, have noted that microaggression tends to fall along a spectrum in terms of intent. Some microaggression is deemed to be intentional, and some is deemed to be inadvertent or unintentional, and so these incidents will fall along a spectrum. And what's really quite interesting from my perspective is to relate this the struggle we're having with the term to capture the complexity and the harms of the experience the complexity of the concept, to some of the discussions or explorations of a particular category of classical Jewish law. Going back to the year 200 or so, in a canonical collection called the Mishnah, and I'm going to just put the text on the screen here so you can see it. There we go. Can you all see it? I think so. So this is in the collection of tort law, laws of damages, tort law in the Jewish classical tradition. There is this really curious category of tortious speech, one could say, that is called ona'at devarim. Ona'ah is a word that I also struggle to translate in a way that does justice to the concept. And if you look at the translations of that word, ona'ah, and in the context of the compound noun, ona'at devarim, verbal wronging, you'll see, and I've called it harmful speech in the title for my little presentation here, you'll see many, many different translators struggle to really capture what this text seems to be concerned about. Some will call it exploitative speech. Some will call it, defamatory speech, which doesn't quite do it. What's really interesting about this category of transgression is that it is a category of speech which is intentionally harmful, but it is impossible to prove that it was intentionally harmful. Only God in this third century source, only God knows whether the person who uttered these words meant to cause harm to the person to whom they're addressed or about whom they're being spoken, and the person who spoke them, presumably in this tradition. So I'll give you very quickly 3 examples. So one may not say to a seller, how much are you selling? How much is this object? If you do not wish to purchase it. If you've ever been to a market in the Middle East, you probably had the experience of asking the seller how much something costs, and then they told you, and then you said, oh, that's too much. And then so they lowered the price. And maybe you said, okay, that's all right. And they follow you, they may even follow you out of the store into the street. And the reason for that is that in that cultural context, if you begin the negotiation, you are understood to be someone who actually intends to make a purchase. We know that in the Roman world, in the Mediterranean markets, the period in which this text came to be in the form we have it, that people tended to be operating in a subsistence economy. One house next to another house would have a little window or opening through which the goods that they were able to grow in their small plot are being sold. And in the Roman markets, you could not deviate from the market prices, which were fairly tightly regulated by more than a little bit. And so if someone asks, how much is this olive oil or whatever it is, and they don't go through with the purchase, there's something wrong. That seems to be the implication here. And so if they walk away and they don't close the sale, people who are watching, because there are 2 or 3 or 4 or 5 other people all next door who are selling the same thing, roughly the same price. If you didn't buy from that vendor, then there may be something wrong. But maybe you didn't buy because you didn't feel well treated, or you didn't actually like the way it looked, and it has nothing you're not willfully harming them. You're not wanting to suggest to the people nearby that there's something wrong with these goods or with that seller. Someone watching you, a casual observer, would not know whether you are trying to harm the seller or whether you actually, for any number of good reasons, chose not to close the sale, which would have been unusual in that cultural context. And those of us who are used to going into stores and asking how much is this item as a form of entertainment might find this, a bit odd. But if you think about it carefully, the salesperson who doesn't close the sale, who's been spending a half an hour with you, telling you how much this costs and opening the case and letting you touch it, and then they miss 3 other sales maybe. Or maybe the manager later says, how many sales did you make? Well, not that many, because I was with this customer for a really long time. Or they just didn't buy it. They might think, I need to lower the price because the price is too high. So their profit margin is going to be reduced. So we don't know the damage that we might do by this form of transgression, and we can't know whether it was intentional or not. And the second case is really interesting too. If someone is a penitent in this category, just imagine someone who has recovered from substance abuse, or someone who has been released from serving a sentence in an incarceration. Don't say to them, remember your former deeds. So what do they mean by that? You're sitting at a party, let's say, with someone, you've known them for years, and you know that they have not had any alcohol successfully for 20 years, and the server comes around with a bottle and they wave them off, and maybe you had a little too much wine, and you kind of an elbow in the side, and you say to them playfully, perhaps meaning to be intimate in a way that isn't appropriate. Remember the old days when you never let a bottle of wine go by without asking for a refill. Or someone got out of prison many years ago, and now they've put their life together in a terrific way, and you're on the golf course with them, and within earshot of the other golfers, you say, remember the old days? I mean, the other people may not know the history of this person. The person who's recovering from having been incarcerated, or who's been successfully on the wagon for many years, may be struggling more than you realize. We don't know whether you'd said that to jeopardize their promotion, because someone might be listening who's going to be considering the two of you for a promotion. We don't know whether it was inadvertent and just insensitive. But again, these are categories of behavior in which speech it's impossible to prove that malice was behind the words, but the impact can be considerable. And this is similar to the context of microaggressions, which, along with Kendi, I don't like. So let me just say a few more words about speech in the rabbinic tradition before I conclude. The classical Jewish legal approach to speech is, I would say, very expansive. It's quite expansive in some startling ways, some not so surprising, and some quite interesting. We expect our moderator this evening to ask questions that the moderator has, without holding back and without wanting to soft pedal the questions that he has. And that is also a value in the classical Jewish tradition. When a famous scholar's prized student passed away, the student who was constantly challenging the scholar on his views, and he replaced him with another scholar. The new scholar, every time the senior scholar offered a legal opinion or an interpretation of a text, the new assistant or study partner would say, "Oh, there's a tradition that supports your view." Yes, there's a tradition that supports your view. And finally, the senior scholar said, "I know there are traditions that support my views. I miss my old study partner who used to challenge me." The rabbinic tradition also famously laments the absent or silent voices. Some would argue that this is part of the construction of a culture of, a celebration of differences of opinion that was broad but not limitless. But nevertheless, there are a scholar who was banned in the Roman period, and removed from his colleagues for the rest of his life. On the way to his funeral, his colleagues who had remained within the circle of scholars were lamenting his absence, weeping at the lost teachings of which they were deprived. They had deprived themselves, as the story seems to suggest, because they had banned him. We also find in the tradition cautions against judges on courts, and we can relate this, I think, to departments and faculties, or any setting, that in a capital case, and this is being discussed in these rabbinic sources long past the time when Jewish judges had any authority to actually execute anyone, but warning of how important it was that when polling the jury of judges, because for a capital case in these sources, it had to be a jury of judges. A warning to the judges on this jury of a capital case to be sure not to ask for the views of the senior jurists before the junior jurists. First, ask the junior jurists what their view is, lest the junior jurists be intimidated by the senior jurists who've already said, "Oh, I think she's guilty," and then be swayed. And in fact, if it's a unanimous guilty verdict in a capital case, there is an automatic retrial, because the assumption is that if not one of the jurors or the judges thought that the defendant was not guilty, then something must have been wrong with the defense. Okay, so there is, and of course, slander, shaming, etc., are also seen as very, very problematic. So the reason I mention this is because, and with this I'll wrap up, that speech is taken very seriously in Jewish tradition, and honest speech is taken very seriously. So much so that in a famous case that many early students of Jewish law learn, if two people are holding on simultaneously to a cloak, a costly garment, and each of them is claiming that it belongs to them, that's their claim. In the legal procedure, where they are now taking an oath to support their claim, they may not say, "This cloak, all of this cloak belongs to me," even though they've made that claim. But when it comes to the court session, so to speak, in front of the judges, the most that either one of them can claim is that no less than half of this is mine. Each of them can say that, because if I say that all of it is mine, then that means that one of us is lying. But if I say that no less than half of it is mine, then the court can then resolve the matter, and is supposed to resolve it by splitting it, not cutting the baby in half, for those of you who remember that story. But the reason that that's instructive, and I talked about the fact that these courts are not ruling over capital cases, this is theoretical, is that the Jewish legal tradition, which includes poetry and history and all kinds of teachings, as a number of scholars have pointed out, it has for the last 1700 years or so, with a few exceptions, largely been a body of academic teaching, of academic knowledge. And it's been a body of teaching that invites thought about moral issues, because it's not applicable largely in actual life and legal settings. And that's why we find cases where the biblical law prohibiting yoking two animals, unlike animals, together to pull a cart, one very strong ox, let's say, and a weaker donkey, that's not allowed. And one of the scholars in this discussion says, what about yoking together a goat and a fish? I mean, obviously that isn't a real case, but they're trying to think at a theoretical level. And what I think they're thinking about here at a theoretical level is, we cannot prove what we might think of today as microaggression in many cases, but the harm is undeniable. The impact on the individual is undeniable. Intent is very important, because if we can discover that it was unintentional, it may help the victim to heal. And for restorative justice purposes, intent is extremely important in cases like this. In legal context, of course, it's it makes the difference in terms of conviction for willful promotion of hatred. But what's important, I think, in this case is it reminds us that we need to pay more attention to harm. We need to pay more attention to victim-centered supports. We need to pay very close attention to doing whatever we can to increase the likelihood of the reporting of incidents of hate and of microaggression, and so that they can be tracked and they can be attended to. Because if you are experiencing as a victim of discriminatory speech or treatment, years and years of what Kendi appropriately, I think, critiques, but what many of us call microaggression, you might just give up complaining if it didn't get you anywhere in the past or you felt it harmed your career. And then when a hate incident occurs, then you might actually not pursue it. And that can be quite dangerous. So to conclude, I think our terms have not quite caught up to our concepts, and the seriousness with which the victims of either hate incidents or a whole variety of microaggressions, the seriousness with which they think about what happened to them and the impact on them, it really calls us to pay far more attention to understanding how to deal with cases where intent may be impossible to prove, or where it might not have been intentional, but the harms are still there. That, I think, is absolutely critical, or we are going to continue to have statistics in the range of 90% of these incidents not being reported. Thank you.
Thank you so much, Dr. Dom, for that very thought-provoking presentation that reminds us all that intent is actually not that important in assessing the amount of harm that speech can do, and the importance of considering the effects of speech rather than their intent, which is preserved in these ancient texts. Our next speaker is Dr. Yulen Echabe, and he will be presenting on What's the Scandal? The tension between religious autonomy, human rights, and the state. Yulen?
Well, thanks also for having me, for inviting me to this fantastic roundtable, and thanks also for my colleagues who have spoken before me, Carol and Robert, and then Hall to follow. I want to talk about a case from the European Court of Human Rights. Now that it has been widely reported that Pope Francis has launched an ambitious project of consultation to renew the church and the church reform. I want to talk about a case about a married priest, somebody who had been fired from his religious post of teaching religion in high school for this scandal, and that's the language that is being used. It's a technical term now of being married. So the case reached the European Court of Human Rights, and the Grand Chamber, with a 9-8 very split decision, decided that there hadn't been any violation of the individual person's rights because the scandal was of a purely religious nature, and that the principle of religious neutrality of the state precluded, in fact, the state and the courts from inquiring further into the substance of the reasons why this person had been fired and why the bishop had not renewed the contract of the person. So obviously the case presents many aspects. There are interesting questions about freedom of expression, the principles of the state neutrality that Carol was telling us that should perhaps be put into question in some cases. My brief comments are going to center only on the notion of scandal that justified the firing. In a nutshell, what I will be arguing is that there is not just a one concept, but at least three different notions of the scandal that are operative in the judgment of the court, and only one of them is strictly religious. Therefore, as a result, I will suggest not only that it would have been permissible for the court to judicially review the circumstances giving rise to the firing, but also to hold the Spanish state accountable for failing to do so adequately. So before I go a little bit into the details of the case, I just have to lay out a few facts for the benefit of those who haven't read the case. So this is a person who was ordained a priest in 1961. In 1984, he applied for dispensation from the Vatican for the obligation of celibacy. He doesn't obtain a response, not until many years later. The following year, 1985, he is married in a civil ceremony. Subsequently, he has a family of 5 children. Throughout the years, he held many positions of responsibility, including he became the director of a seminary in the region of Murcia in Spain. In 1991, he started to teach religion and ethics in a public high school under renewable one-year contracts. in 1996, a newspaper article appears in a local newspaper where the applicant is featured with his family and other members of the movement for optional celibacy, to which the applicant belonged. So all these facts that I've just mentioned were well known to the bishop, as well as to the large teaching community of parents and other teaching members of the high school. So a year later, this article appeared, that is 13 years later than it had been originally requested. He finally received a rescript, that's a technical term, from the Pope, granting the dispensation from celibacy. But in the rescript, the applicant was barred from teaching unless the prudent judgment of the bishop decided otherwise, and provided that there was no risk of a scandal. That was the language that the rescript had. The language was remoto scandalo in Latin. So the bishop, having received this rescript, argued that the applicant was in a situation that had become a matter of public knowledge. The diocese therefore decided not to renew the contract. Obviously, this starts a very lengthy judicial path. In the first instance in Spain, he goes to the employment tribunal, and he received, surprisingly, an affirmative decision where the judge in first instance says that he had been discriminated on account of his family situation. Immediately, the diocese, of course, appeals. The High Court of the region of Murcia quashed the judgment, arguing that the bishop had merely used his prerogative to avoid scandal. Again, the word scandal. The applicant now goes to the Spanish Constitutional Court in a recourse called amparo. So you're trying to basically claim a violation of a fundamental right. And in essence, the Constitutional Court in Spain argued that the scandal was a religious concept, and that the state was in fact barred from passing any judgment or even on the compatibility between the actions of persons and the orthodoxy of religious faith. Other important circumstances before going into detail is that teachers of religion in Spain are regulated by an agreement with the Holy See, between the Spanish state and the Holy See of 1979. Teachers of religions are appointed by the administrative authority, that is by the state, but only from those who are considered suitable by the dioceses. So technically they are not civil servants, but they're paid by the state. So their remunerations come directly from the state. So I think this is relevant. As to who might be suitable, there is a canon law which states that those candidates are suitable who are outstanding in true doctrine, in the witness of their Christian life, and in their teaching ability. That's kind of the language of canon. So now this is the background for the case that arrived first to the first instance chamber of the European Court of Human Rights, a 7-member chamber. And in line with the Spanish Constitutional Court, the chamber took the view that those circumstances that used to justify the non-renewal of the applicant's contract were in fact of a strictly religious nature, and the principles of religion freedom, and in fact the principle of state neutrality precluded from carrying any further examination. And that's in a nutshell what they argued. There was just one sole dissenting voice, curiously the Spanish judge, the Spanish ad hoc judge, who noted that the situation had become a scandal only after the news had been reported in the newspaper article. So in his view, the notion of scandal, the notion of religious scandal, could not be in fact invoked because the situation that gave rise to it was known to the dioceses from the beginning. So the question is, what's the scandal? That's what I want to talk about in my remaining time. So scandal is not expressly defined in the canon, but it usually refers to a certain objective situation that seriously affects somebody's moral standing or his capacity to lead an exemplary Christian life. For example, in the past, and this has changed, it was used to deny communion for divorced or remarried persons, because the argument was that it may cause negative judgment or create a scandal among the faithful, among the other faithful. So unlike those situations, however, here in the case at hand, the objective situation of being married was known before he started teaching in 1991, both to the diocese and to the larger high school community. So arguably, the diocese was reacting not to this objective situation of breach of certain sacramental duties, but to a different social and frankly, somewhat prosaic notion of the scandal, namely seeing the negative press coverage. The news article, in fact, made it impossible for the bishop to look the other way. The question then is this notion of the scandal, therefore, covered by the same principle of religious autonomy? To put the question sharply, I will say, is avoiding public embarrassment justification enough to shield religious organizations from judicial review? To put it somewhat in jest, but perhaps not inaccurately, is the scandal, in other words, like the one imagined by Inspector Renault, the memorable character played by Claude Rains in Casablanca, when he purports to be shocked that there is gaming at risk? I don't want to push this argument too far, but I want to suggest that religious neutrality will not be violated if the circumstances given rise to it had been critically examined. But still, I want to note yet a third meaning of the scandal, which is operative in the judgment of the Grand Chamber. And this third notion is meant to respond to the challenge that the situation was too well known for the bishop to claim a scandal so late in the game. The thrust of this new argument is provided by the Spanish Episcopal Conference, who acted as a third-party intervener. In their view, the non-renewal of the contract had been related not to the applicant's status as a married priest, but to the fact that he had acted publicly against the church. The Grand Chamber, in fact, agrees, and they go even further. They say, despite the fact that his situation had been tolerated for many years, the applicant should have known that the public display of his militant stance on certain precepts of the church will not be or will not go without consequences. In fact, the Grand Chamber say, freedom of religion does not enshrine a right to dissent within a religious community. This is certainly a new argument that can explain both the dismissal and the inability of the state to do anything about it. But the argument raises a novel issue about the meaning of the scandal. In this interpretation, the non-renewal is the result not of a religious notion of the scandal, but a form of reprisal and quieting dissent. This is worrisome for two reasons. On the one hand, the court is assuming facts not on the record. Other than his photograph being featured in a newspaper, the applicant had made no public criticism of the church, nor did he ever spoke against celibacy in the classroom. The mere fact of being featured in a newspaper article is reinterpreted by the court as an act of open defiance. From the fact that the applicant did not avoid contact from the press and did not complain about the press when the article came out, the court suggests that the applicant adopted a militant stance against the church. The second worrisome issue is that the allegedly religious notion of the scandal acquires rather political undertones. What matters ultimately is not that he was married, but that he dared to defy the church, and that he had done so with what the court calls an active and public campaign. Mind you, the campaign amounted simply to being featured in a newspaper article as member of an association advocating optional celibacy. In sum, I would say the scandal is not exclusively religious in nature. To conclude, I would say my point is not to question the prerogative of the Catholic Church to consider suitable candidates, but the idea that the scandal is a religious concept that the state organs cannot review is not borne out by the facts of the case. The court might say that religious autonomy, and I'm citing the court here, precludes the national authorities from ruling on the substance of religion notions such as a scandal. But what they are doing, in fact, is insulating acts of reprisal against those who dare to have a different view. Thus, the mere presence of the applicant and his family in a newspaper article is turned into an act of dissent that the religious organization might suppress without question. If I'm right, the court undertakes eventually no real balancing there between the rights of religious communities and the individual's rights to respect for his private and family life. As András Sajó, who's one of the dissenter members of the court, put it, one cannot enjoy one's family and private life if one has to hide it. Thank you very much.
Thank you very much, Yulen, for that. This is, as a scholar of the Mediterranean and a scholar of vernacular systems of morality and so forth in the Mediterranean, I find this really compelling because it underscores how throughout Mediterranean societies, small scale and large scale, you can violate all kinds of norms, but when it becomes public, everybody will tolerate all kinds of violations. Ask me how I know, not right now, maybe later. But when it becomes public, when you then make a public announcement, or when you make un'erogazione, how do you say that, to have your act of non-celibacy accepted by the church, well, then all bets are off. And this is another way that that members of a court of law, members of the court of civil law, are influenced by the same vernacular system of morality that is influencing the church officials. So I think that that's where that went sideways, but I might be wrong. Finally, our last speaker today, well, not our last speaker, but our last presenter who will be speaking about a particular case is Dr. Hoi Kang, who will talk to us about what's law got to do with it, religion through the lens of law. Hoi?
Thank you so much. And thank you to my fellow presenters. Thanks for the invitation to participate. And thank you to all the participants who are in the room, who are listening to us and spending time with us. I think what I'll do is I'll not actually focus on a specific case, but rather abstract out a little bit and to explore a kind of conceptual problem in freedom of religion. So I'll make essentially three basic arguments. The first argument is that there is a classic distinction in theories of religion and theories of religious freedom. And that distinction is between interference, state interference with religious beliefs, which Carol has helpfully sort of laid out in the Canadian context, right? And state neutrality, right, with respect to religious beliefs. And that is something that Yulen has very helpfully laid out for us. So first, a distinction, the classic distinction within concepts of religious freedom. Second, within just debates about religious freedom. Second, I'll argue that there's a kind of overlap. There's a kind of zone of overlap between interference and neutrality. And when I point out the sort of overlap, I'll raise some implications, and there are essentially two kinds of implications. The first implication is it reveals what Carol has pointed out earlier, that there is a kind of individual focus, individual right focus of religious discourse about freedom of religion, about judicial discourse, legal discourse about freedom of religion. Second, I'll sort of pick up a thread that Yulen has laid down for us and argue that this overlap, these implications of the overlap, are grounded in a concern for neutrality understood in the way that Yulen has pointed out, right? A concern about courts interfering or stepping into religious debates. So that's the second argument. Second argument is about the overlap and its implications. Third argument will bear on whether this framework works, the classic framework works in respect of collective claims by religious communities of the kind that Carol has identified. So three core arguments, and I'll start now with the distinction. So this standard distinction in freedom of religion is between neutrality and interference, right? So the state can violate freedom of rights to freedom of religion by taking a position on religious matters, right? So the state endorses a particular religion through, for instance, enacting a legislation that requires stores to close and if that legislation is called something like the Lord's Day Act, right? In that instance, the court is expressing a preference with respect to religion, right? And it's endorsing a specific religion. It thereby violates the prohibition against neutrality. Second, the state may violate the individual's rights to be free from interference in their religious beliefs. And that may arise irrespective or sort of independent of any violation of neutrality, right? So for instance, if you have a Sunday closing law, right, that is mandatory, it may burden the practice of sort of Saturday Sabbatarians, yeah? But the motivation for that law and the title of the law may suggest absolutely no intent for the state to take a position on religious beliefs. You may have interference without a violation of neutrality. That is the classic distinction in freedom of religion. So let's now turn to points of overlap, right? Now, there are going to be cases in which, and in fact, even in the classic cases of neutrality, right? So the classic case of neutrality in Canadian constitutional law is this case called Big M. It's about this Lord's Day Act legislation, right? And the way the court understands the violation of neutrality is to say that what this act does is it compels people to accept beliefs that are not their own, essentially, right? It interferes with the religious freedoms of individuals. Right? Other kind of classic violation of neutrality cases are cases in which you have mandatory school prayer, or you have a prayer before a municipal meeting, right? There is a violation of neutrality, but that violation of neutrality results in an interference with individual conscience, individual rights of belief. And indeed, that's how the Chief Justice in Big M conceives of the harm, such as there is in a violation of neutrality. Right? It's a harm to the individual capacity to choose to believe or not to believe. Okay. So we see from this kind of overlap, right, between the individual and belief, interference, and neutrality, a kind of focus, right, even in the conception of neutrality, on individual rights. Now, why would the court tend to focus so heavily on individual rights? Well, or an individual conception of religion? Well, in a famous case called Anselm, the court defines religion, and along the lines that Carol has pointed out to us, right, as a sincere individual belief in religion. And there's a really long definition of what religion is, but essentially a kind of connection with the divine, right? An individual belief in the divine. Now, one of the reasons for doing this, right, focusing on the individual, is to avoid the problem that Yulin has identified for us, right? By simply focusing on sincerity of belief, right, the courts are absolved from having to enter into religious debates about what constitutes a valid or invalid religious belief, right? They do not enter the sphere, right? They demarcate the boundary that Yulin has pointed out for us, right? The boundary between what is internal to the governance, the internal definition of religious belief, right? And the appropriate role for court adjudicating a claim under religious freedom. Okay. So the classic distinction, we see how the distinction breaks down a little bit and how there's overlaps and what motivates those overlaps, right? What motivates the overlap, at least in part, is this concern of the courts to stay outside of religious disputes and not involve themselves in religious debate. Right, and thereby to take essentially kind of liberal position that Carol has identified, right, to adopt the position of the neutral state. So that, I think, is sort of a kind of encapsulation of how religious freedom is sort of classically understood and some tensions that are within the classic conception. Let me turn now to where the classic conception may break down and why we might need a different way of understanding freedom of religion. So there are certain cases in which we are not so much concerned about an individual claim of right, but rather about a community's ability to define for itself, right, its religious beliefs in a way that arguably runs up against some sort of public interest, right? So Carol's case is an example of that, but there are other cases. So classic cases are cases around education. Right. So of course we can trace the claim about Catholic schools' ability to control its own curriculum down to the individual claimant's belief, right? But what's, I think, more sort of at issue in those kinds of cases is the ability of the school to define for itself when something like a curriculum is at issue, right? What it understands to be the appropriate governance of its own matters, collective governance, not individual rights. Yeah. And so this raises, I think, a set of complications, right? So once we shift the focus from an individual conception of rights, right, and towards this kind of argument about collective governance, right, we start to put pressure on this idea that courts can maintain the kind of posture that Carol has identified, this posture of sort of liberal neutrality. Because what's specifically at issue is the capacity of the schools, in the collective or body, in our instance, in our example, schools, to define for themselves their jurisdiction, the appropriate boundary between them and the state. Yeah. Now, in individual freedom of religion cases, right, the court often says something like, it is the case that the individual, whether or not someone sincerely believes that a religious belief, that they have a religious belief, is to the individual. Yeah. But whether there has been a violation is an objective matter, and the courts will assess whether there is an objective matter. I want to suggest that in collective claims, that ability of the court to define that boundary of whether or not there has been a violation or not is potentially at issue. That is, a community may say for itself that this is a violation of our jurisdiction to govern ourselves as a religious community, right? And so this claim of neutrality, this claim of the ability of the state to objectively assess whether or not there has been a violation, which works, I think, quite well in the individual rights claims, breaks down, I suggest, in collective claims which give rise to the kinds of arguments which I've described as jurisdictional. So that is the distinction, the classic distinction, points at which the distinction breaks down, and a kind of challenge to the classic model of freedom of religion discourse. So where does that leave us? I suggest that one way of thinking about freedom of religion claims in the context in which there is a collective claim of jurisdiction or collective self-governance is that we borrow from the places in Canadian constitutional law or constitutional law generally where jurisdiction really matters. So Yulin has given us one example, that is the example of judicial review of administrative action, right? But another is federalism, right? And so one of the things we want to think about is what is the sphere, appropriate sphere of the jurisdiction of a collective group? How should we analyze that, right? And one way we might think about this is the extent of, and these kinds of tests proliferate in Canadian constitutional law, but we want to think about the impact of a state measure on the ability of a group to self-organize and to order its own affairs, right? And measure the extent of that, the impact of the state action against the state's objectives in regulating for the public good. So that, I think, is a jurisdictional conception of religious freedom, that is a departure from the classic model of religious freedom, and that sort of picks up on some of the great work that my colleagues have already presented so far today. And that takes me to exactly 10 minutes. Thank you so much for your time.
Hoy, thank you so very much for that provocative presentation that points out some flaws in our system, and also you did such a good job of bringing in our other colleagues' contributions. Justice Gomery, you now are in the unenviable position of having to somehow draw together the brilliant but rather disparate presentations of our colleagues today. So I'm going to go ahead and turn the discussion over to you.
Well, I have questions. I have questions, and the interesting thing is that the questions that I have that arise out of one talk run together with the questions that arise out of the next, and they make me think that there are some underlying commonalities here. And also there is perhaps in all four implicitly a critique of, call it a Western liberal vision of what rights are, what law should be, what law should do. And I'd like us to talk about that a little bit. Let me just start with giving you some of the questions. Could there be a law that is not value-laden? Or, in Dr. Blackburn's words, that does not proceed on the basis of underlying ontological presumptions? Doesn't the law have to start by standing somewhere? And by doing that, doesn't the law necessarily implicitly invalidate alternative worldviews? Isn't that one of the neat things about the liberal conception is its notion that it's possible to accommodate many, many, many different points of view. That's the liberal vision, the marketplace of ideas, the marketplace, not the marketplace, but a public square in which you believe what you believe and I believe what I believe. And as long as we're not hurting each other, it's okay. Of course, then we start talking about hostilities, aggressions, microaggressions, if you will, and that all becomes a little more problematic. And so Dr. Dom's talk says maybe the liberal view of the public space in which people just robustly present their points of view is not a satisfactory one. Maybe it results in a lot of people getting hurt unnecessarily. And maybe there are lessons for us in the way, for example, the rabbinic tradition thought about this. I want to come back to that, but dealing with the two last talks, Professor Eksabe and Professor Kong, whom I think I saw some commonalities of approach. Who decides on the scope of religious autonomy? If it's a communitarian thing, if we're talking about the ability of a community to decide on to settle its own practices, I certainly understand that perspective. Is it possible to deal with that again from a neutral perspective? Is there such a thing as neutrality when we're talking about this? Different communities have very different beliefs. One person's notion of a religious perspective on marriage, for example, as the union of a man and a woman, is another person's violation of human rights. It's another person's discrimination made manifest. We've had our own struggle in Canadian law over that particular one. It strikes me as having some similarities to the struggle described in the Martinez case. If we're going to think about the matter from the perspective of jurisdiction, from a jurisdictional analysis, then I suspect we're going to find that we're going to be more comfortable with that model when we're thinking about religious viewpoints that we approve of or can accept, and less comfortable with that model when we're talking about religious viewpoints that make us very uncomfortable. I think that there's a certain tendency to prefer models that give us results that we like. And Canadian constitutional law and the jurisdictional, I don't think I'm speaking out of school here. If you look at the Canadian constitutional law and the division of powers, you see it lurching from one position to the next, depending on what judges thought about the particular case at hand, in a way that's very difficult to rationalize. I mean, people have tried, people have written great books about it, but you can stand back from it. You can say, gee, I'm wondering whether this really represents a coherent jurisdictional worldview, or whether it represents something that's awfully results driven from case to case. Is that where you're going to end up with if you adopt a jurisdictional model? That's a question for Professor Kong. I'm going to stop in a second because I hope I've given people questions to answer, or people are going to want to say, no, you're wrong. I'm hoping for that. But before I do, I want to say one thing about where our tradition comes from. John Rawls, a professor of law and an important liberal thinker of the mid to late 20th century, suggested that essentially the liberal Enlightenment worldview came from the struggle in Europe that accompanied the Protestant Reformation, and that it was the result of the fact that neither side was able to win by force of arms. They simply fought themselves to a standstill. Tens of millions of people died. They were per capita bloodier wars than anything we've seen in the 20th century, says Stephen Pinker. And finally, they arrived at a notion of tolerance, not as a virtue, but simply as something that a kind of a grim necessity. And then the thinkers came along and said, maybe it's more than a grim necessity. Maybe getting along together is with views that you view as not just wrong, but profoundly wrong, is actually a virtue. Maybe the good society, the good culture is one in which we accept, even praise our differences. That's a very modern idea. There was nothing like that preceded it, I don't think. And I think each of you in your own way has called that into question. Not in a profound way, not in a we should reject this, but in a maybe we've gone too far kind of a way. And so I'm just wondering, what do you say to that? Do you say yes, or do you say no? Gomer, you've got it entirely mixed up. I'm not doing this at all. I invite you to respond. Someone.
Any of our panelists who would like to respond are free to unmute themselves and jump right in.
Well, I'll start since I think I was the last target in the line of questions. So, Justice Gomer, thank you so much. Those are such incredibly thoughtful questions, and they go, I think, really right to the heart of so many of the presentations from today. Let me pick up on your question directed at me, the specific question you directed at me about jurisdictional analysis. And the core of the question, as I understand it, is jurisdiction, schmerisdiction, right? That is, you can talk about jurisdiction, but what you are actually if you look at the cases, what you actually have is a kind of results-driven pattern of decision-making, right? That doesn't really speak to some sort of overarching principle of jurisdiction, but rather about the preferences of the judges themselves. So I think that the first response would be to say, well, is that distinguishable meaningfully from charter jurisprudence, right? So if that is the case in the jurisdictional analysis of the division of powers, right, is that substantially different than what courts and judges will do under a Section 1 analysis and application of Yoke's test, right? So that's just, so in what the initial response is to say, I am not sure that the realist critique that you're advancing of jurisdictional questions, it applies only to jurisdictional questions. Second, on the broad kind of Rawlsian framework within which I think Western legal systems work. So I agree, and I don't think I am putting that, I don't think I'm contesting that. In fact, I don't think I'm contesting the underlying goal of at least Rawlsian political liberalism, right? That is, I think what we want to have are things like overlapping consensus, ways in which we can build on consensus so that we can live together, even in the face of profound disagreement. I don't think I am challenging that. What I am doing, I think, is shifting the analysis and saying that a jurisdictional analysis picks up on the nature of religious claims, right? In a way, certain kinds of religious claims, right? So you can turn a claim about, say, the ability of a law school to govern itself, or the ability of Catholic schools to govern themselves, right? You can turn those claims into claims of religious right. I just think that's a distortion of what they are, and that a jurisdictional analysis is more true to the actual nature of the problem. So finally, how does that fit within a general kind of Rawlsian framework? I think that what we want to do in the kind of jurisdictional analysis is to have rules about how we live together, and rules that we can generally live by. And that's precisely, I think, the hope of jurisdictional analysis in something like federalism, right? So there may be profoundly different views of what the Canadian state is, But one of the things that jurisdictional analysis can do is to allow for those views to coexist while at the same time deciding disputes. That's my aspiration. I think with the project, it's sort of relatively early in its gestation, but I thank you so much for the very thoughtful question.
I could offer some responses if other people are still thinking. I thank you. Thank you for the questions and the summary and the drawing together of our presentations. And so I just want to go back to Justice Gomery, what you said at the very beginning. If my memory is correct, what you said was, aren't all legal systems, you know, sort of culturally based or based on some kind of a ontology? And yes, so my answer as an anthropologist would be yes, of course. Certainly, I mean, I can invoke any number of anthropological ancestors who have been fascinated with law in culture or law as culture, who've made this very point that legal systems are culturally informed, that legal systems are cultural systems. Bronislaw Malinowski, if I can just mention him, he was one of our, if you do legal anthropology, you're sort of, inevitably you encounter Malinowski's argument that cultural rules are laws. And so for Malinowski, everything was a law, right? He merged law and cultural codes, norms, rules of conduct. He said that they're basically the same thing. And there's been a lively debate about that. I think that maybe one of the things that an anthropologist or others who look at law and our law, so contemporary Canadian law, I think that the point to be made is that as much as our legal systems, our courts, our legal professionals are, you know, really invested, not wrongly, really invested in the value of objectivity and neutrality, and seek to apply the law in a neutral way, in a sort of culture-free way. I think it constantly bears repeating that separation cannot be made. I mean, you, Justice Gomery, I think you in your reflections, you suggested that you don't see the law as sort of completely culture-free, but I think that sometimes in its operation, it can make that presumption. And when I say it and the law, I know I'm homogenizing and being maybe overly general there, but sometimes that presumption is there. It slips into this institution that is values free, divorced from culture and belief and values, perhaps somewhat like science. Sometimes people who study science and technology make a similar point, that sometimes practitioners of science sort of slip into this idea that scientific practice is culture-free, belief-free, etc. So I think that the point in reading a judgment like on the Tanaka ruling, I don't know what the answer is, apart from maybe resolving Aboriginal rights and title first, prior to an issue around a sacred site. But I think just the point, the court, in the ruling, they struggled for neutrality. They struggled for neutrality a lot. And it was really interesting. And one of the things that they wrote when the majority wrote about why the law cannot, why Section 2A of the Charter cannot protect a spirit, cannot protect the object of belief. And they wrote that, if I remember, they wrote that that would involve the law or the courts in actually assessing the merits of a belief. And I had to read that over and over and over to try to understand what the point they were trying to make was. They said the court cannot go in there and look at the belief itself, the qualities of this God, this spirit, to make a judgment on how to protect it. They said the court can't do that. That voids neutrality. And so I found that very interesting. So those are my reflections. I won't say any more. Leave it to my other participants.
If I might just pick up on Carol's last point on neutrality, and also to answer your questions, Justice Montgomery, was somehow the assumptions underneath, I think, the principle of neutrality is one of, as you pointed out, of tolerance or respect. So the idea being that you're neutral because you want really to respect the specificity of the religious belief and religious autonomy. One way of thinking about it is to think that that is not the best way to respect religion. And so the argument that I was trying to make precisely was not that the judges were insufficiently neutral when they were not being neutral, but actually that neutrality is not the best way to think about those interactions between religious belief or religious autonomy on the one hand, and then the state on the other. But again, the underlying assumption continues to be one of having a better or more respectful relationship or dialogue with religious associations or organizations in this case. So it's not one necessarily of supplanting a value of tolerance from something which is untested and yet to be seen, but I guess to question the idea that neutrality, that fear of as Carol has pointed out, of trying to understand those beliefs as such, it's not the best way necessarily to engage in those intercultural differences. So that's kind of how I will approach it. One of the judges in dissent talks about the need of translation, and I always like this way of because translation forces us to deal with each other differences as opposed to shielding us from, which I think in the end, the principle of neutrality, as my colleague Hoy was speaking, it conceives of those relationships as walls of separation, and that's of course in the American jurisprudence too. And it seems not a very fruitful way of thinking about those relationships, as I prefer to call them.
This is such an interesting conversation. Thank you, Justice Montgomery, for your remarks, and thank you to everyone else. We could have a really rich conversation for far more time than we have. Just a few quick observations to share. One is just around the impossibility of neutrality at I think in a fundamental sense. There's a wonderful popular observation that circulates in the circles of students of Talmud that notes that all of the tractates of the Talmud, this is 5,400 pages of folio editions, hundreds of years of collected teachings, largely in the most important edition, it's in present day, what remains of present day Iraq. What the observation is that all of the tractates of the Talmud start on page 2. And the reason they all start on page 2 is because there is this understanding that page 1 represents the body of learning and of assumptions and attitudes that the students bring to the study of Talmud. Nobody starts on page 1. So it's formalized in a sense with starting on page 2, but there's something very interesting there. Incidentally, the Hebrew Bible Genesis in the Hebrew, also it starts with the second letter of the alphabet, not the first letter, which is essentially silent. But when it's pronounced that first letter, the one that's not there in the book of Genesis, before the word Bereshit, when beginning, it's the aleph it's a glottal stop. And it sort of makes you choke, and you should choke, because there is something profoundly, well, it's the profound responsibility that in the exercise of power, that calls one to examine one's assumptions and unsettle them. I will never think of the university as a phenomenon in the same way again after having read Rauno Kokanen's Reshaping the University. Indigenous epistemes, responsibility, indigenous epistemes, and the logic of the gift, by the Sami scholar. I will never see the university in the same way. It's about unsettling the assumptions that we bring. And I think that similarly, we need to rethink about the assumptions that we bring to considerations of the collision of principles of freedoms. I'm a big supporter for the most robust protection of expression and speech. At the same time, I'm aware that the line between the freedom of expression and the freedom from harassment, the tension between those two, the line between those two, that line runs through the bodies of disproportionately marginalized persons of particular intersecting identities that are identifiable. And it makes us, I think, pay more attention to the impact of where we draw that line. It's not about constraining speech in a blunt way or controlling our freedom to ask questions and encounter different ideas, but it's about calling into paying more attention to harms, to impacts, and to the consequences of the ways that those lines have been drawn until now, largely by a particular demographic within the population. There's a fascinating a series of legal conflicts particularly in the medieval period between those Jewish scholars who were deeply committed to the project of Talmud study, which I've tried to give you just a little bit of a taste of, and those who produced codes. When Maimonides, the great legal scholar and philosopher and physician to the court, which gave him the in many respects the power to do this, when he realized that people actually needed a readable code, and there was an interest in the part of the state in having a legal code for the Jewish community, Maimonides wrote one in fairly simple Hebrew. And it was scandalous, if I can pick up on the term earlier. It scandalized the many rabbinic scholars because he settled cases, so many Talmudic units of study, and are not resolved, partly because they didn't, in many cases, have to, because they didn't have the power to enforce their decisions, except in some limited cases and for some limited periods of time. But Maimonides left out the footnotes, the citations. He cut out the parts in the Talmudic versions that said Rabbi so-and-so says this and Rabbi so-and-so says that. And Rabbi so-and-so learned from Rabbi so-and-so, so that when the scholars were learning these traditions, they were aware of the scholarly tradition that had given rise to the particular view they were encountering. And then someone else could say, I never heard that tradition. And there could be challenges to, the veracity or just the clarity of the way in which it was understood. So settling law, narrowly, rigidifying it was seen as deeply problematic. And I would say similarly, there was also scandalous in the Middle Ages to move from, as my late teacher Amos Funkenstein pointed out, to move from, for in Jewish scholarly circles, belief in God to belief that God is like this, that, and the other thing. There was a great reluctance to define what God was all about, to pick up on the important point made by one of my colleagues about determining what is let's say an authentic way of practicing a particular tradition, the community's collective authority to determine for itself what is the law. But of course, we know that but we know that all communities also have power dynamics, and not everybody is able to participate in the conversation. And as Daniel Boyarin, one of my teachers, famously pointed out, the women characters in the Talmud, in texts that are controlled by men, are essentially men in drag in a way. And what's really ironic about the textual unit from which I drew the Mishnah in today's case about harmful speech is that there's a fantastic story at the heart of that Talmudic unit about the banning of a particular rabbi who refuses to concede to the majority decision about a particular issue, and he weeps, and in the story he has supernatural powers in a sense. His grief can cause fields to catch fire and the walls of the schoolhouse where they're studying to collapse. And his wife, who is a scholar in her own right, has to watch him for the rest of her life and his life, because if he falls down in prayer, she knows that his prayer of pain for having been verbally wronged will be answered immediately by God. And the one moment she takes her eyes off of him, he does that. And the guy who banned her husband, who caused all this pain, who is the patriarch, is her brother. And as soon as he falls down to pray, her brother dies, right? And what's fascinating is there's a Ukrainian, now it's Ukraine, rabbi who wrote a similar code, a very simple code that everyday Jews could read, because they're not going to study the Talmud, most of them, to tell them what to do. He adds a few lines that are not there in the earlier sources that says a man should be especially careful with the way he speaks to his wife, because women are their feelings are so fragile and they can be easily hurt. And it's kind of shocking in a way to read that in the 1850s or so that he writes this, when commenting on a text in which the central characters are a woman, scholarly woman, who is so watchful, she's on top of everything that's happening, that she tries to keep her husband from losing control of his own feelings. And he's the one who weeps in this tale and in other stories about him. So you can see the construction of gender, and I only point that out because of the importance of focusing on who is making the rules, who's writing these texts, who's drafting these laws, and who is determining what is and isn't a legitimate place to draw cut the line in the tension between these these colliding values or principles. I think that we're impoverished because of the lack of access to indigenous legal scholars and scholars of many other traditions that can help us to understand more deeply the complexity of the issues with which we're wrestling. I'll stop there.
Thank you very much, Dr. Dahman. Thank you to Justice Gomery and to all our panelists today. Our audience members have been very patient, and I'd like to open it up to questions from the audience. Again, you can put them in the Q&A, which is at the bottom of your screen. Just click on that and go ahead and type your questions in there, and I will read them out to the panelists. I don't see any questions right now. We should probably give our audience members a few moments to type their questions in the Q&A. They don't show up right away. I mean, they don't show up while a person is typing magically, automatically.
Maybe we've driven them to despair.
So maybe I'll pick up a little bit on, like, while we're waiting for questions to come, I'll pick up a little bit on the brilliant interventions of my colleagues to respond a little bit to Justice Gomery's, I think, core question, which is, how do we, in matters of religion and secular regulation, how do we bridge a kind of ontological gap, basic differences in claims about truth? And I think some of the, one partial way towards that answer is to have, as Dr. Don has pointed out, a judiciary that is sensitive to the sort of diversity of claims, including religious claims that are made. Right. So there is a way in which I think religion, almost more than other kinds of experiences. We'll just say religion is sort of importantly distinct in that it really does require something like an internal point of view in order to fully grasp it. And so one possible response to your question, Justice Comrie, is a more diverse judiciary that can at least use the tools of the state, which are always going to be partial in their views, but is more sensitive to the diversity of claims that come before it. So I think that's one partial recognition, one partial way of doing this. Another point I think that Yulin pointed out, raised was just a different posture, I think, of courts towards religious communities. And so if you think of the courts as being in dialogue and in trying to understand, contend, and being willing to sort of try to resolve contending conceptions of religion and engaging in that dialogue rather than erecting a kind of wall of separation of neutrality that neutrality requires, then maybe that can get you some further way along to understanding views that are fundamentally different than the sort of dominant majority worldview. So these are just two possible ways of responding, I think, drawing on some of the interventions of my colleagues.
I want to say something about that. Say a couple things. One is, I don't think the law is neutral. I don't think the law can be neutral. I'm not sure there's anyone here who's disagreeing on that. The law has to stand somewhere. It has to begin somewhere, and it begins from, among many other things, some of the values that are inherent in, say, the Charter of Rights, which is a document which instantiates both individual and communitarian rights, which is an interesting thing in and of itself and very Canadian. The problem is, I think, as Professor Kong has fairly and correctly put it, that one has to attempt to understand and grapple in an honest way with very different points of view. And so we tend to fall into process as a means of doing that. We make process rules that have to do with how we will listen to people and that we will listen to people. And we rely on those. And we try to engage in reflection. We reserve judgment in order to think about things and not simply be driven by our intuitions, which Daniel Kahneman tells us are suspect. We try to be aware of the invidious effects of stereotyping and the dangers that are involved in simply taking that which you might have learned in school at the age of 10 as gospel, or that which one might have learned in chapel or in synagogue or wherever, as something that reflects everybody's reality. When all that is done, the obligation of a judge is to give a judgment, and the judgment will not be neutral. The judgment will take sides, and the judgment will speak. The judge will purport to speak with authority because that's the task that has been given the judge. That is the judge's obligation, and what everybody expects. And the consequence is the judgment will itself, whether the judge wants it to or not, be presented as, in some sense, a neutral determination because of the process, because of the attempt. Whether the judge has succeeded in that is another question entirely, but that's what the judge is trying to do, and that's the way the judge's work is going to be perceived. If the judge's work isn't perceived that way, then what the judge has done is the judge has become a political actor in the use of state power for purposes which are ostentatiously or perceived as political, and that is frankly a very bad thing, and a troublesome one. So I don't know how one solves that problem. I'm not sure that it's solvable. I see we've got two questions that have come up, so we should turn to them.
We do have two questions. I'm going to read the first one first. It's a question for Professor Blackburn. Would you say that the court's desire to remain neutral on the claims made by religion, here with regard to the existence of grizzly bear spirit, has the effect of actually making a negative judgment on those claims? That is, tacitly acknowledging that it sees those beliefs as invalid? I ask this because if we were honestly perfectly undecided as to whether a powerful and important spirit existed in a particular place, common sense would presumably prompt us to seek further evidence or consultation before taking measures like building a ski resort that would disturb or destroy it.
What a well-crafted question, and thank you for that question. And I agree with the premise here, which is that in effect, making this negative judgment on the claim while saying we respect your right to believe in grizzly bear spirit, and we have no doubt that your belief in grizzly bear spirit is 100% genuine. Nevertheless, the resort is going to proceed. That is how can that ruling be made if the court could hold it as a possibility that grizzly bear spirit existed? I think that was, I was also trying to get at that. How could they make that ruling? As you say, I have to do this so I can read because of my glasses, as you say, because if we were undecided as to whether this powerful, important spirit existed, how could we proceed with the authorization of a ski resort? So I think this is an effect. This is an effect of this kind of ruling on this sacred site claim. The court is they're saying, yes, we respect your right to believe, but nevertheless, we're going to permit this action that is going to drive this spirit away. There's such a dissonance there.
And I think the next question also gets at this. It gets at the way that that in liberal democracies, religion is always fundamentally about belief, and that belief is private, it is internal, it is intangible, and it is disconnected from anything else. Jessica Main asks, as a scholar of Japanese Buddhism and Japanese religions, I was struck by the assumption that sacred landscapes and other sacred things beyond the skin of the individual can be severed from a judgment of whether an individual enjoys freedom of religion, particularly the freedom to practice. Does the Canadian notion of freedom of religion demand an itinerant or unconnected notion of religion itself, tied to no particular place, where all the necessary parts can be carried within the practitioner?
So Jessica, that's nice to see you, Jessica. And as someone who, so Jessica and I had the same supervisor in Buddhist religions and Japanese Buddhist religions. So it's nice to see you, Jessica. Yeah, I don't think that's the case. So I think that there are claims in freedom of religion, which are in Canadian constitutional law, which are about this place. So can you erect a sukkah on a condominium balcony? Can you zone a Jehovah's Witness worship hall in one place or another? So I think it's a bit of an overstatement to say that Canadian constitutional law denies the importance of practice. And I would say that there are many cases in which that's precisely the issue, and the court has protected those rights. So I think it's a bit of an overstatement, but I do think that what's underlying your question is a certain conception of religion in Japanese Buddhism, which is, I think, very different than the conception of a religion which is so focused on individual belief in Canadian constitutional law. So I think, for instance, the practice-based versions of Japanese religions that you study, Jodo Shinshu, the Pure Land Buddhism, I think that's something that's quite distinct. The sort of idea of religion that is instantiated in something like Jodo Shinshu is something quite different than the picture of religion that emerges from freedom of religion jurisprudence in Canada.
Thank you so much, Hoy, for answering that question. And Jessica, thank you for asking it. Well, we have now come to the end of our time, and also there are no additional questions. So once again, I'd like to thank the panelists and Justice Gomery for being here today and for this very stimulating afternoon and early evening. I'd like to thank all of the people who attended. I'd like to thank the Public Humanities Hub and the Faculty of Arts, especially first year and interdisciplinary programs, for their support. And I wish you a very pleasant rest of the evening.
Thank you.
Thank you, Sabina. Thank you. Bye. And thank you, Heather.
Thank you, Heather. Heather rocks. Thank you. It's been a pleasure. Bye.
Thanks, everyone.
Thank you. Bye-bye.
Enjoy your night.
Yeah.
Nice to meet everyone. Thank you.
Likewise.
Thank you.